California is coming for your assets. So in this video, I'm gonna go over the asset protection strategy you can use if you live in California to protect your assets before it's too late. I'm Douglas Lodmell, asset protection attorney since 1997. That's almost 30 years. And I've done nothing but asset protection, which is helping clients protect their assets from all sorts of threats. And today I'm gonna go over how in California, we can set up an asset protection structure for you to protect your assets before it's too late. So why is California different from other states? California is different because it's just the litigation culture there is much more aggressive. First of all, the state of California itself is very aggressive, and particularly with wage and hour claims. So they've created something called PAGA, which is Private Attorney General Action, which basically authorizes regular law firms to file an attorney general action on behalf of the state and sue you for wage and hour violations. This is combined with the fact that California has very, very strict wage and hour regulations. If you run a business in California, it's even difficult to properly do your wage and hour. For example, in most states, overtime is paid by the week, but in California, it's by the day. And in most states, you're required to give your employees break and meal times, but in California, you're required to make sure that they take them. So it's just a very aggressive state. It's one of those states and has a set of legislation around it, which pretty much guarantees that most people who are employers in California are probably violating something in the wage and hour. Then combine that with basically opening up this private attorney general action to every law firm in the state who wants to sue, and what you have is you just have a flood of lawsuits. Basically, the PAGA claim can be made against any employer, and they can just try to get into your books and your records and see if you're doing something wrong, which again, you probably are. I have seen clients and they've described it as a worm that they get into their business, and it just, one employee, next thing you know, it just worms around all the way through the business. And it can even lead to class action lawsuits. So it's just unlike other states where this isn't really possible, where you don't see this kind of aggressive litigation or with this private attorney general action. California has basically opened up the floodgates for litigation. So if you're a California resident, if you're a California employer, all people need to be thinking about asset protection. Asset protection for you is highly relevant. We look at California clients differently, not in that we do the asset protection differently, which I'm going to talk about how do we do the asset protection, but that the need for it is just so much greater. Also, assets are higher for most California clients. California clients, the average price of a home is so much higher. The amount of money that a lot of our clients make in California is higher. The number of employees that they have is higher. The risk associated with each employee is higher. The amount of litigation in general is higher. The courts themselves and just the way they see litigation and the way that they are fairly liberal about how they allow it to proceed forward is much higher in California. So it's mainly the fact that the risk in California is so much greater that sets it apart from the other states. So how do we protect you if you're a California person and you have assets? Well, we're gonna look at your assets and we're gonna take a two-stage approach. The first step is to do what we call exemption planning. Exemption planning is looking at the things that are already exempt from lawsuits. So for example, retirement plans are exempt to a degree. In California, it's limited by a standard, basically says if the judge thinks you need those assets for retirement. So even the retirement assets, which are theoretically exempt, are not as exempt or strongly exempted in California as they are in other states. So unfortunate, but that's just the way it is. Other things like your homestead. So if you, in California, you could have up to around $800,000 of equity in your home and be protected from creditors. Well, if you have a home with $2 or even $3 million of equity or more, that's not going to cover it. So the exemption is part of it, but then we're going to have to do something else to protect the excess equity. Other things that might be protected in some states would be like life insurance, cash value, but in California, it's not. So exemption planning is definitely part A in doing an full asset protection analysis. But in California, believe it or not, the exemptions are more limited and less strong than they are in other states. So in California, we almost always are moving to the second stage, which is actual asset protection planning. And what that looks like in California is that we are looking at the assets and determining where can we put them to where if you got a judgment, the creditor would have a difficult time reaching them. What that looks like is a layered approach starting with limited liability companies. So let's say you have real estate, rental real estate in California. We would create a limited liability company and put that rental real estate in the LLC. In turn, the LLC would be held by a holding company. In our model, most often we're going to use what's called an asset management limited partnership, which is normally going to be done outside of California. So you're going to get some diversity of jurisdiction. You're going to get a state which actually has better charging order protection than even California. And you're going to get 2 layers. So we've already layered it. So let's say we have maybe 3 or 4 LLCs on the bottom for various assets. They could be your boat is in one LLC, it could be your airplane is in one LLC, you could have some rental real estate or investment real estate into 3 or 4 more LLCs. And you might even have a few more businesses that you have which have value that we need to protect and segregate into other LLCs. Some or all of those LLCs would then be contributed to the holding company, the AMLP, which we're going to base in Arizona, that Asset Management Limited Partnership, giving us 2 layers of charging order protection. So if you're sued and you get a judgment against you, the judgment is against you personally, you. Your assets are no longer held by you, they're held by these holding companies, by these LLCs and the holding company, the Asset Management Limited Partnership. And then the final step is to use what's called an asset protection trust. And an asset protection trust can basically be done in 3 different ways. You can do it as a fully foreign asset protection trust in a jurisdiction like the Cook Islands or Nevis or Belize. You can do it as a fully domestic asset protection trust in a jurisdiction like Wyoming or Nevada or Alaska, or you can do it as a hybrid between the 2, which is called a bridge trust. The advantage of the foreign trust is that it is incredibly strong. Those foreign jurisdictions do not recognize U.S. judgments. They have short statute of limitations. They have very high burdens of proof. It's very expensive. And if you lose, you have to pay the legal fees and costs of the winner. So suing an offshore trust is a very intimidating prospect and a huge uphill battle. The downside of the foreign trust is that they are more expensive. They have more compliance. You're not going to be in direct control of that trust. And it's just more expensive to maintain, and you have an offshore component. So the compliance is often a big deal. So for many people, it's just a little bit overkill. And so often we won't use a fully foreign trust right out the gate. If we go to the other side of the spectrum and we look at the fully domestic trusts like Wyoming, Nevada, Delaware, Alaska, there's actually over 20 states that have a domestic asset protection trust statute. California is not one of them. So right there, you know, we already have an issue. But in all cases, a domestic asset protection trust is just that, domestic, which means it cannot disregard a court order like a Cook Islands trust can. It cannot disregard a judgment or a judicial proceeding from another state. It has to respect those because we have something called Article 4, Section 1 of the U.S. Constitution, which says the states must grant full faith and credit to the laws and judicial proceedings of the other states. It's why you don't have to get a new driver's license when you cross state lines. Your driver's license is respected because of that full faith and credit clause. Well, that's also why your Nevada or Delaware or Alaska Asset Protection Trust cannot just disregard a judgment from California. And we have a lot of case law now on domestic asset protection trusts. And while I'm not going to go so far as to say that they have no place, I am going to say that they're not something I use for my clients. I don't personally consider them strong enough. I think the limitations they have are significant, and I think there's frankly just a better tool. And that leads us to the third option, which is the bridge trust, which I mentioned is a hybrid between a foreign and a domestic asset protection trust. So what is a bridge trust? A bridge trust is actually drafted like a foreign trust. It's actually registered offshore in a foreign jurisdiction, but then it is bridged back. And for the purposes of IRS compliance, we meet the two-part test, which is set out in 7701A30E, which has a court test and a control test, meaning a court in the US has to have primary supervision over the trust, and a person who is a US person must have primary control over the trust. So we meet that two-part test, and by doing that, we are essentially accessing both jurisdictions. Since the trust is registered offshore and treated as a foreign trust from the foreign jurisdiction's eyes, but it meets the 7701 two-part test here, so it's treated as domestic trust for tax purposes, we can have a trust that has the foreign level of protection with domestic simplicity. That means that there's no foreign trust compliance requirements, there's no extra enhanced compliance at all. The tax returns are grantor, which means disregarded, so all the income from the trust is actually just passed through to the grantor or the client's personal tax return. The client can be the trustee in many cases, directly maintaining direct access and control of the trust assets themselves. However, if we ever have a problem, we ever have an actual threat to the assets, the protector, who has a role in the trust, can declare an event of duress, which can create a reaction that ultimately leads in the trust moving fully offshore. The offshore trustee, who's in an emergency position, not an active position, would become the full trustee. And then they would remove the client as the trustee. And at that point, now we have dropped the US part of the trust, and it is just a foreign trust with the strongest jurisdiction in the world and the strongest protections in the world. That's how a bridge trust works. And because we get really the best of both, I consider it really the ideal tool for most clients that call my office. I would say 95% of the people who call, the bridge trust is the right choice for them. The other 5%, we are usually going to a fully foreign trust right out of the gate. Almost never are we just going to recommend a fully domestic asset protection trust. So if you're in California, that's exactly how I would analyze your assets and your estate. I would look at the risks, I would look at your assets, I would determine what is exempt and what could be made exempt from creditors, and then whatever's left over, I would look at placing in LLCs, the Asset Management Limited Partnership, with the bridge trust sitting at the top, protecting everything. So if this rings a bell for you, if you're in California and you want to talk about asset protection, I would click the link below. You can schedule with my office. We'll do an analysis. I can go over everything in detail. If this makes sense for you, what your options are, what the cost is. And it's imperative that you do it before you have a problem. That's the one Achilles heel of all asset protection structures, is that if you transfer assets after you have a problem, now you have what's called a fraudulent transfer issue, or in California, it's called voidable transaction. In other words, the transfer itself can be voided. So you set up a trust and LLCs and an asset management limited partnership and you transfer everything into it. That's the transfer they're looking at. And if you do that and you've already had an issue, well, then that whole transfer can be reversed. So it's important that you do whatever planning you're gonna do now, before you have that problem. So if this is interesting and you want to have a conversation with my office, click the link below and I'll look forward to speaking with you.